Let's talk about all with the man you just heard from. That is Andrew Laperierre. He is the head of U.S. policy at Piper Sandler. We gave you a little plug there for that call back in April. But, hey, that was then. This is now, Andy.
Yeah.
What do you think is going to happen now?
Well, I think that the administration has a really bad argument. I mean, they basically are arguing that the president can declare a phony emergency and then just do whatever he wants on tariffs. And I don't think IEEPA or any other statute, as I said back then, and I think it's still the case. And as the court said yesterday, if you look at that IEEPA statute, it says, there has to be a bona fide emergency. The remedy that you're going to put in place under IEEPA, under the law, has to track what the actual emergency is. So you say, hey, we got fentanyl, so we're doing tariffs. The court said that doesn't jive. Congress didn't write the statute to give the president that kind of authority. So you've already heard what this strikes down. I think there are different statutes that are out there, and the court decision yesterday referenced them. So there's Section 122. If we have a balance of payment issue, the president can impose up to 15% tariffs for up to 150 days. So there's lots of other tools in the toolbox for the administration. They can bring back a lot of tariffs, but I think what they can't do with this IEEPA ruling is they can't do just across the board tariffs. They're going to have to justify their tariffs either on a country by country basis or product by product basis. And so I think ultimately the Supreme Court is going to side with this unanimous panel, because the argument, I think, is it's almost a slam dunk. I just don't understand how you could make the argument the president can just do whatever he wants on tariffs.
Andy, we're showing 3 other options he could pursue, actually 6 of them, and it's that 6th one on the screen now I wanted to bring up. Section 338, this is the Smoot-Hawley rule, really, that goes back to 1930. And we were talking to Dan Clifton last hour. He said, why bother going the 122 route? That's the 15%, for 150 days. He said 338 is much more broad. As far as I understand it, you can impose tariffs of up to 50% on a trading partner. And if they retaliate, then you can do even more. The country could be embargoed. So would you expect that to be a route they pursue? And would there be any legal problems in doing that?
I think there would be a legal problem in doing that. I wasn't able to see much of what you had on your screen, but I think what 338, the problem for the administration, if they want to invoke 338, is that 338 requires that the administration show that the unfair trade practices that other nation is engaging in discriminate against the U.S. and are unfair to the U.S. So that basically it's unequal treatment for the U.S. compared to other nations. So, that you couldn't possibly just do a 10% across the board tariff and cite 338, Section 338. So I don't think that works. I mean, one of the things that there's actually another ruling that went against the administration that came out a few minutes ago, and
with on the same,
and what that ruling said, which is a very important point is, what's the use of all those statutes that you just listed there? What is the use of them if by passing IEEPA, Congress just said, Mr. President, do whatever you want? And so they didn't do that. Congress didn't do that. And that's why you have all these distinct tariff and trade rules and regulations. And I should say trade laws and sections of them that allow the president to do this. So I think that 338 is not a blank check. None of these are a blank check. They all can apply in various circumstances. So president's got a lot of tools. He can do a lot of tariffs. He just can't do anything.
Andy, the 122, the court itself basically kind of seemed to say you could go the 122 route and impose up to a 15% tariff, I guess, for up to 150 days. Maybe that can be extended. A lot of people are building that into their base case at this point. Do you think that would also be inappropriate?
No, I think the president could do that, and I think the court decision yesterday green lighted it. It just said, look, this is in making the case of why IEEPA doesn't allow the president to just do whatever he wants because there's a trade deficit. The court said, look, there's this other statute that Congress passed that says if there's a trade deficit, you can do this. So by obvious implication, and this is how the court looks at things, if Congress already had this other statute, then what's the point of it? And so it means that by implication, they didn't just give you a blank check in IEEPA. So I think the president could use it. And I think that what you're hearing from the administration, I think given where the president's head is at, I think he's going to most likely, bring back tariffs using these other statutes. So it's a setback, and I think a big one, but it doesn't mean he doesn't have a lot of other tools.